Yes, good morning everyone. Welcome back to my YouTube channel. Today we are going to discuss an interesting course unit, and that course unit is Law of East Africa. In this course unit, we are going to understand what is Law of East Africa all about. We are going to discuss what is East African community. We are going to discuss the laws governing the East African community, and also we are going to look at various protocols that are also under the East African community. So, before we start, let's first look at the background of the East African community, where it came, how it started, what were the loopholes, like the failures. Is it still there? Is it still in existence? So, that's what we are going to start looking at. And now, the background of the first East African community, it started in 1967. 1967, this is when the first treaty for the East African community was signed. Uganda signed, Kenya signed, and by then Tanzania, initially it was Tanganyika and Zanzibar. They joined and they created Tanzania. So now it was Uganda, Kenya, and Tanzania. They joined hands and they signed a treaty for the East African community. And however, things started changing up slowly, and we are seeing in 1971 when Amin became the president. Remember, Amin, when he became the president, he abolished the Ugandan constitution. There was coup d'etat everywhere. So this one, it restricted also movement, because by 1976 we are seeing that there was restriction of people from moving from one place to another, and also from one country to another. So this was the collapse, this was the end game for the East African community. And the first East African community, it only survived for 10 years, from 1967 to 1977. That was the time frame it served. But however, we have to see the reasons as to why it failed. What was wrong? What came all about for its failure? And some of the reasons as to why the first East African community failed, it was the first one, lack of strong political will. Whereby by then we see that the presidents, by that time, they never had that political will, they never had that unity to grow together, because most of them, they were selfish. They all wanted to become the president of the East African community. So this showed that most of them were selfish, because they wanted the positions for themselves, for their own personal interests. And another thing, we are seeing that the private sector, the private sector wasn't given opportunities to participate. That's why the first East African community collapsed. And also, we are seeing there was an equal development. For example, look at Kenya. Kenya is near the Indian Ocean, so it's at the sea. So meaning that exportation, like exporting and importing, is very easy, because it's near the sea. Are you seeing? So Uganda is a landlocked country, so there is no way that Uganda can develop or can be at an equal development with Kenya. Are you seeing? So those are some of the challenges as to why things became hard for it at first, and led to the failure of the first East African community. And initially, before the first East African community was formulated, they wanted to, number one, they wanted to have the same currency, like all East African community member states. They have the same monetary currency in terms of cash, like finance, the same money. Secondly, they wanted to have one president. They wanted to have free trade and movement within East African community. They wanted to have, let me say, easy utilization of resources, whereby I'm a Ugandan, I can go to Kenya, I can start up my industry and maybe start exploiting the resources. Like, they wanted to go together, they wanted to be united. Are you seeing? So those are some of the reasons as to why they formulated the first East African community. However, the East African community was later revived in 1999 when the Treaty of the East African Community was signed. However, it also entered into force into 7th July 2000 when the three countries rectified the treaty, and that was Uganda, Kenya, and Tanzania. Right now, there are 8 members in the East African Community, and these include have DRC, that's Democratic Republic of Congo, we have Burundi, we have Kenya, we have Rwanda, we have South Sudan, Uganda, Somalia, and Tanzania. Those are the 8 member states of the East African Community right now. Now the question comes, what was the purpose? What was the aim? What are the objectives of this East African Community? Why was it revived in 1999? Why did it come back? And when you look at the treaty for the establishment of the East African Community, Article 5 of this treaty, it provides for the objectives as to why this East African Community was revived. And some of the objectives is to promote sustainable utilization of resources, to strengthen cooperation between these member states, to enhance the role of women in cultural, social, and political, economic, and technological development, to promote peace and security. So those are some of the objectives as enshrined in Article 5 of the treaty. And also, you shouldn't forget that this treaty gets its mandate from Article 2 of the Treaty for the Establishment of the East African Community. Now, I'm going to take you through some crucial or key articles within this treaty so that at least you can try to dig depth and understand what each means. So, there is Article 3 of this treaty. Article 3 provides for the membership of the community. The membership for the community, it's only the summit that allows new members or new states to join the East African Community. But however, there are some criteria they follow. For example, you shouldn't be very far from the other members of the East African Community. Let me give an example. Assume South Africa wants to join the East African Community. Remember, South Africa, it's at the tip. It's there down, according to the map of Africa. South Africa cannot be admitted as a member of the East African Community because it's very far geographically away from other members of the East African Community. So if at all you read Article 3, you will understand it in depth and see it has some criteria they also follow when admitting these new member states. Well, I have a case. Under membership, I have a case, and this case is for Patrick Ntege, Walusimbi, and 2 others versus the Attorney General and 5 others. In this case, the applicants were opposing the application of the Republic of South Sudan to join the membership of the East African Community. However, here the court dismissed the application on grounds that it's the summit's discretionary mandate to decide which country gets admitted as a member of the East African Community. So this case has brought the other aspect that it's the summit, and the summit, who heads the summit? Those are the heads of states. Those are the presidents of various East African member states. They are the people with the power to decide which countries can join the East African Community. Then also, according to Article 4 of the treaty, it provides for the legal capacity of the community. As remember, this East African Community, it's a corporate body, and therefore it can sue or be sued, and it's represented by the Secretary General. Then another article that you shouldn't skip, that is Article 6. Article 6 provides for the fundamental principles of the community. And the first fundamental principle is the mutual trust, political will, and sovereign equality. Then the second one is peaceful coexistence and good neighboring. The third one, it is a peaceful settlement of disputes. The fourth one, it's good governance. And under good governance, we have adherence to the principles of democracy, the rule of law, accountability, gender equality. So most of the cases that we're having under the law of East Africa, they normally uh, be in rule of law. So that's why I advise you that when you are quoting some of these articles, don't leave out Article 6 of this treaty. Then also another article that you shouldn't skip out, that's Article 9. Article 9 brings out different organs within the East African community. And the first organ is the summit. The summit, those are headed by the heads of states, those are the presidents. Then another organ is the council. The council, those are the ministers in charge of the East African community. For example, like here in Uganda, we have Right Honorable Arinaitwe Rebecca Kadaga. She is the minister of the East African community. Then another organ, those are the coordination committees. Those are the permanent secretaries. Then another organ, those are the sectorial committees. And another organ, that's the East African Court of Justice. That's represented by the judges. Then another organ is the East African Legislative Assembly. Another organ, that's the Secretariat. Those are the organs under the East African community. You should read those members you should read the responsibilities of those members in the East African community, and you see what they do, the role they play in the East African community. Then also we have Article 27. This is a very important article in the law of East Africa. Article 27, it provides for the jurisdiction of the court. That is the East African Court of Justice, its jurisdiction. This court, it shall have the original jurisdiction in regards to interpretation and application of this treaty, that treaty of the establishment of the East African community. So be keen about that. Now the question comes, who has the legal capacity? Who can bring a case in the East African Court of Justice? The first one, we have natural or legal persons. These are provided for under Article 30. A natural person is you, an individual. A legal person, that's a corporate body or entity. They can file a case or bring a case in the East African Court of Justice. Another one, that's the Secretary General. Another one, a partner state. A partner state can bring a case against another partner state, or can bring a case against the Secretary General or any, depending on the circumstances. Then, according also to Article 31, the employees can bring a case against the Secretary General. These employees must be working within the East African community. Are you seeing? Then I'm having some cases, and those cases, the first one is Adam Chomuhendo versus Uganda and 6 others. Well, in this case, the applicants went to court to restrain the summit from permitting DRC Congo as a member of the East African community. But however, the court held that the summit has the power to admit new members, and therefore it had no jurisdiction either to stop or to intervene. And this shows that individuals, or what we call natural persons, according to Article 30, can bring a case before the East African Court of Justice. Then another case, that is Honorable Margaret Ziwa versus the Secretary General, where she brought a case before the East African Court of Justice claiming that her removal as the Speaker of the East African Legislative Assembly was unfair and it was unlawful since it did not follow the proper procedures. And the court went into considerations and tried to see whether her removal was lawful or unlawful, and it concluded that her removal was unlawful due to quorum. The quorum wasn't enough. The quorum wasn't, as per the procedure, the quorum at that time was not enough, and therefore her removal was unlawful. And therefore the court held that her removal as the Speaker of the East African Legislative Assembly was unlawful. So these cases show that these natural persons can bring a case before the East African Court of Justice. So that's all about today's session on the treaty for the establishment of the East African Community. If this video has been helpful, please kindly share, like, and subscribe. The reason as to why I'm insisting that you share is because this video can also be helpful to some other people or some other scholars who would wish to learn about law of East Africa. So please kindly share, like, and subscribe so that you do not miss out.